This is Nick Gebelt. I'm a bankruptcy attorney here in Whittier, California, and this is one in a series of videos I'm making on Chapter 13 bankruptcy. Now, you might want to take a look at some of the previous ones to sort of get a running start, and I've also made a series of Chapter 7 videos that will be helpful. Take a look at those as well. Now, one of the things that is a big limitation in Chapter 7 is there are some kinds of debts we simply cannot get rid of. If you take a look at those Chapter 7 videos, you'll get the lengthy list. Two of the debts that are in that list that you cannot get rid of in a Chapter 7 bankruptcy, but you can get rid of in a Chapter 13 bankruptcy, that is, meaning you wouldn't have to pay them 100% of what you owe them, are debts that are the result of doing willful and malicious harm to property. You still can't get rid of debts that are willful and malicious harm to a person, but you can get rid of debts that are the result of willful and malicious harm to property. A second debt that is not dischargeable in a Chapter 7 bankruptcy, but is dischargeable in a Chapter 13 bankruptcy, is a debt that's assigned to you in a divorce decree or a separation agreement that is not domestic support. Now, we think of domestic support as child support or alimony. What other kinds of debts are we talking about here? A simple example will suffice. Let's say when you go through your divorce that the divorce judge, as part of the dissolution, assigns debts. So, for example, maybe there are 4 credit cards, an American Express, a Bank of America, a Chase, and a Capital One. And the divorce judge says to you, I order you to pay the American Express and the Bank of America, and then your ex-spouse has to pay the Chase and the Capital One. If you went through a Chapter 7 bankruptcy and you were able to get rid of those debts, then none of those 4 banks would ever be able to come after you to collect on those debts. But if they took a look in their records and noticed that your ex-spouse was also on those debts, they'd go after the ex-spouse, who would then say, I'm sorry, we went through a divorce, my ex-spouse is supposed to pay it. Well, the credit card company is going to say, you can't shuffle papers between the two of you and prejudice our rights. And so that ex-spouse is going to go back to the divorce judge and say, you ordered my ex-spouse to pay this debt. The debt isn't being paid. Order my ex-spouse to pay me so I can pay the debt. And the divorce judge would comply. So that's the setting in a Chapter 7 bankruptcy. But it's different in a Chapter 13. Because that kind of a debt, which is a debt to an ex-spouse, is dischargeable in bankruptcy. However, you cannot get rid of domestic support obligations in any chapter, but a debt to a spouse or an ex-spouse that is not domestic support is dischargeable in a Chapter 13 bankruptcy. If you have questions about Chapter 13, please give me a call at 562-777-9159. This is Nick Gebelt signing off.